passed, but Congress is getting into the act, so to speak. There has been pending for some time now a law called the 401k Fair Disclosure for Retirement Security Act, which right now it's only pending on the House side. Senate hasn't passed anything at all yet, and even the House hasn't passed it yet. But if it were passed in its present form, it would require even more disclosure than the regulations that the Department of Labor is expected to issue next month would require. More disclosure by the service providers, and in particular more disclosure to the plan participants, because that's still been, the participant side of it has been kind of less of the focus up until now. There's been more requirement on disclosure to the government, and the 5500s, as you may all know, are all public information. I mean, the 5500s themselves are picked up on, like there's a website called freearisa.com, so those of you that work in the field I'm sure are aware of this and maybe use freearisa.com for sources of information about particular plans or prospective clients. But sometimes employers aren't aware of the fact that what goes on the 5500 will end up out there being part of public information. So the focus up until now has been disclosure on, to the public and the government on that form. And now with these regulations, more disclosure from the service providers to the employer and the plan administrator than has ever happened before. But now we're going to start getting into soon the next and maybe the final stage, and that's more disclosure to the plan participants. And that's kind of key to the next slide here too in terms of litigation. There's over the past however many years, Tim, maybe 5 or so years, there's really been quite a few lawsuits, class action lawsuits. I mean, I think 30 is on my slide here, but that's really quite a few, because they're not exclusively, but largely one law firm, plaintiff's law firm in St. Louis, Missouri, but I think maybe a few other firms are getting into the act too, have brought many of these lawsuits against some really big named employers like Boeing and Caterpillar, Walmart, and the thrust of these lawsuits has been that the plan fiduciaries on the employer side overseeing how the plan is run have been asleep at the switch, haven't asked the kinds of questions to find out what kind of indirect compensation is being paid to the plan providers, haven't made sure that the plan participants are aware that maybe some investments are more costly than others and so forth. So it's a lot of it is related to the lack of disclosure, and so they're claiming breach of fiduciary duty, and because litigation takes so long, a lot of these cases, even though they've been filed some years ago, a lot of them are still just kind of plugging along in various stages of litigation. There was one significant case that has, already basically gotten to a final resolution, and that happened here in Wisconsin, actually, because at least in the Western District of Wisconsin, there's the federal court there has what the litigators call the rocket docket, because the judges there have such an emphasis on speed and getting the cases to trial quickly and getting them resolved. So one of those cases happened to be against John Deere and Fidelity, their service provider, was brought in the Western District of Wisconsin. And fortunately for the employers and the plan sponsors, the case was resolved favorably to the employer, and that case was already appealed to the 7th Circuit in Chicago, which oversees it's the Court of Appeals for Wisconsin, Illinois, and Indiana, and that court approved it too. So we have this probably the most advanced case in this area here in Wisconsin, and it threw the case out and said that that there was no breach of fiduciary duty. But that doesn't mean that other cases in other parts of the country wouldn't reach different conclusions. Plus, the facts of each case are a little bit different, in terms of what information is being provided to the plan participants and how diligent how the plans are structured. I mean, one aspect of to that case that was very influential to the court apparently was the fact that there was kind of a brokerage window feature in that plan that allowed participants to choose not just among the funds, Fidelity funds, but they could invest in just about anything out there through that window, through all the other kinds of funds too, even non-Fidelity funds. And that was a significant factor in why that court thought that well, the employees are the ones making the choices here, and so don't, complain, there really wasn't a breach of fiduciary duty because they weren't forced to invest in certain things that were maybe more costly than others. If some were more costly, it was because the employees chose that more costly option. So, but other courts might view it differently. So, even though that was a very favorable case, this whole area is going to continue to bubble along, and we may see some significant court cases that might affect how, the kind of advice we would give to our clients before long. So this whole issue of 401k fees, we've been talking about it for a number of years, but I think we'll continue to talk about it for quite a long time too, because it's an area that's a lot of regulation, litigation, and so forth, and responsibility on plan sponsors to be aware of what fees are and so forth. So it's probably going to be a standing agenda item here for a while.